Last night, we finally received the official affidavit the Marion Police Department used to get a search warrant for the raid on the Marion County Record newsroom, as well as 2 employees' houses. The affidavit details a lot of the same information we've been telling you about for the last week. Eric Meyer and Phyllis Zorn attended a public meeting with a Kansas congressman held at Carrie Newell's business. She asked them to leave. In the affidavit, the police department said a Record employee was committing identity theft, which is why Police Chief Gideon Cody wanted the search warrant instead of a subpoena. KAKE's Jocelyn Schifferdecker spoke with the Kansas Press Association's attorney to get a better idea of what this all means.
The attorney I spoke with says the affidavit shows there was a clear First Amendment violation. The part he found the most concerning was the failure to follow the Privacy Protection Act.
What it speaks to is a need for education about the Privacy Protection Act. It needs to be ingrained in every law enforcement agency in the state.
Max Couch specializes in media law and represents the Kansas Press Association. He says the Privacy Protection Act calls for police officers to ask for a subpoena instead of a search warrant when investigating newsrooms, except in limited circumstances. One being if the journalist is involved in criminal activity and investigators are worried evidence will disappear. In the affidavit, investigators say they had reason to believe Phyllis Zorn, a Marion County Record reporter, was committing identity theft, that she downloaded a copy of Newell's driving record in order to verify information she had received from a source. Marion Police Chief Cody wrote in the affidavit that in order to download those records, Zorn would have had to impersonate Newell based off of the options listed on the state's website. However, under Kansas and federal law, vehicle records fall under the Open Records Act, making them public. The Kansas Drivers Protection Privacy Act says driving records are public for use in research activities and for use in producing statistical reports, so long as the personal information is not published, redisclosed, or used to contact individuals. Couch says he finds it interesting that the federal law itself wasn't cited in the affidavit, and instead the list of when third-party members could download records was included.
If the federal statute were cited, it would show that research on its own, as long as that information is not published, is enough to be a protection.
Further, Couch says the search warrant is too broad. The affidavit says police wanted to take any computer or digital device that had been used to access the Kansas Department of Revenue, a public website. Couch calls this the essence of an overreach.
There's just absolutely no justification for a search warrant under these circumstances. There's just a myriad of steps that could have been taken.
Records also show the court didn't process the probable cause warrant until 3 days after the raid on the newsroom in Marion. Jocelyn Schifferdecker, KAKE News, on your side.